Hasina Gori takes us back to the week in court.
8 years since the murder of soccer sensation Senzo Meyiwa, and we're still far from understanding the circumstances that led to that fatal shooting in the home of a singer and his former girlfriend Kelly Khumalo at her mother's home in Vosloorus in 2014. And we've seen the trial begin in the North Gauteng High Court this Monday, with the first state witness being called and many twists and bombshells coming through this week. I want to bring in a legal expert, the managing partner here at Fember Attorneys, Jocelyn, who's been following the matter as well, to get some insight on what we've seen and to understand better. Thank you so much for joining us. Let's start with, it's taken 8 years to have people brought to trial and to be prosecuted. What's the consequences of such a delay in a criminal matter?
Thank you so much, Hasina. I think this is a very public matter. There's a lot of public interest, and because of the high-profile nature of the case, the questions that people are asking surrounding the delay in the proceedings, what the effect on the family of this situation is, as well as the public, are very important. But I also think it's important to create context. And in the legal profession, we always say that the wheels of justice turn very slowly, and I think that people are starting to see that that is a very real thing. The examination of witnesses, especially when a trial begins and where you have a situation where, in this case, the state has a long list of witnesses and they are keeping their cards very close to their chest. I understand that Sergeant Thabo Mosia was I think he was witness number 41, and his testimony alone, so the examination, cross-examination, which we are still within, and re-examination has taken 3 days so far, and we don't know how long that's still going to take because the matter's been postponed to the 30th of May. It might take a year for this trial to finalize. It might take 2 years. It might be a significant period of time, notwithstanding that it's been 8 years, because 8 years simply means that the state is ready to proceed, and it believes that it has enough evidence to take the matter into the trial process. But there are so many uncertainties, so many things could happen, as we've seen. The removal of the watching brief from court, objections raised during cross-examination, adjournments because of technical issues, things like that can affect the progression of the trial. So I think we just have to all wait and see. Everybody needs to sit tight and just pay close attention to the context within which these proceedings are transpiring.
You mentioned the watching brief, and many don't understand maybe the role of a watching brief, firstly, but also why we heard that objection from the defense on Friday, and then from the state itself on Monday, asking for the Magdalene Winsami, the watching brief for Kelly Khumalo, to be removed. Can you explain that for those that might still be confused what exactly transpired there?
So I think, again, context is extremely important, because the watching brief essentially is there to assist people who are not parties to the proceedings, such as witnesses and such as people who have an interest in the matter. So to begin with, the parties to criminal proceedings are the state as well as the accused. Those are the people who are entitled to the entire record of documentation so that they can each present their cases. Witnesses in the proceedings, and we understand that Kelly Khumalo will be a witness for the state, are not entitled to exhaustively participate in the proceedings. And the reason for that, and I think the reason for the removal of her watching brief, was primarily because of the objection raised to that, and that wasn't properly ventilated in court. So the judge made a decision over the weekend, and it was just very quickly decided, and everything happened fast. So people's responses were quick, and there was a huge misunderstanding surrounding that. So I think it's important to understand that Kelly Khumalo is a witness for the state. So her listening to the testimony of other witnesses and getting insight on whatever it is that's being ventilated in court does pose a risk to the right of the accused to a fair trial, because it means that there's a possibility, there's a likelihood, and this is purely based on potential and safeguarding certain things. It's meant to preserve that right and to ensure that there's no collusion between witnesses. So that was the reason for her removal. She might have been allowed in the proceedings, in the pre-trial process, so that she could explain to Kelly Khumalo perhaps the dynamics in court, take notes and just give her advice based on that. But I do think the court made that decision based on that. And yes, they could have very well, walked out of court and watched the the proceedings in a televised basis, but also a witness statement. All the witness statements are made available to an accused person before the trial even commences. So if you doctor your evidence as a witness based on what, for instance, Sergeant Thabo Mosia has said, it will become very apparent to the judge, and that will be noted. So that's the balance between broadcasting the proceedings and actually having the watching brief presently in court.
That was something that we've seen, come out from public comment as well around, what's the difference between watching it live and then those statements, and that explains a lot more. We've seen Sergeant Mosia on the stand this week, bringing that forensic evidence, bringing the evidence of those that what he collected that day. How important is that specific evidence when it comes to the state's case?
So the evidence of Sergeant Mosia is absolutely critical to the case, and that is why he is the first witness that takes the stand. He is the first forensic investigating officer that arrives on the scene. So he interviews witnesses, he makes observations about the state of the crime scene, and he takes notes on what is physically present. He takes photos and he collects the evidence that will form the basis of the state's investigation. So it is absolutely crucial that his evidence is credible and that the findings of the court in relation to what he has said and what has been cross-examined and re-examined is found to be reliable and credible, because the state bears the onus of proving the guilt of an accused beyond a reasonable doubt. If there's a reasonable doubt that's raised by the defense, for example, where certain questions were asked about the tampering with the crime scene and the length of time that passed between the incident that actually happened and the time of arrival on the crime scene, those questions are raised for a reason. They're raised to raise a doubt regarding whether the crime scene was tampered with and whether the four accused are actually the ones who committed the crime. And if his evidence fails, the entire case of the state falls apart, especially if those doubts are corroborated by other witnesses that the state will interview or examine, and that will be cross-examined. So that is crucial to the trial.
We saw that line of questioning from Advocate Tefu. They're really trying to chip away at the credibility when it came to, as the tampering as well as the length of time. But what exactly he observed, also accusing him at some point or telling him that he may have been managed on the scene. And I want to go into the objections that the state raised to the line of questioning. Is it normal for us to see heads of arguments bring board or a formal application bring board with regards to objections, or is it done, during the proceedings as the questions are asked?
It definitely is not standard procedure to raise heads of argument afterwards, but the reason I think this happened was because perhaps the state had some time to comprehensively put together their objections. And what we noted from the proceedings on Tuesday is that there were many interruptions, from the states. They did object to certain things. There were also many interruptions by the judge. And I think this is important to understand, because the right of an accused to a fair trial as well is central to this conversation, because the number of times a judge interrupts during cross-examination could be raised by the defense to say, well, I didn't get to properly cross-examine this witness. I didn't get to properly represent my client to the best of my ability, and that's something that Advocate Tefu said as well. So it's really striking a balance between objecting excessively and the court interrupting excessively, and the court also not cross-examining the witness. That needs to be achieved, and I think that possibly, and I'm just drawing inferences from the proceedings here, possibly the state wanted to raise those heads of arguments in a fresh proceeding, and so that the day was not overburdened, because already they were pressed for time. The judge did mention the time aspect at some point, and I think Advocate Tefu said at that point that he's not really concerned about time. All he's concerned about is getting to represent his clients to the best of his ability.
And we saw proceedings ending on Thursday. On a side note, and I want to understand, what does the impact of Advocate Tefu's arrest have on the Senzo Meyiwa trial, if any? We've heard his instructing attorney says that it doesn't have any impact, but do you think that it may have some kind of impact on this case?
So I think the distinction between an attorney and an advocate needs to be explained in these circumstances. With the Legal Practice Act, you have advocates who practice from trust accounts who take instructions directly from parties. But in this case, we're dealing with an instructing attorney who is instructed by the client. There are situations where the client will jointly consult with, give instructions to, and take advice from counsel and the attorney jointly. So if Advocate Tefu gets caught up in a trial and he has to attend his own trial, it's very obvious that if he doesn't receive indulgences from the court insofar as his attendance to that trial is concerned, he will have to forego representing his clients. But then representation, so the right to representation of the accused, doesn't necessarily fall away because you have an attorney who is fully apprised of what has transpired so far in the matter. There wouldn't really be a need to request transcripts from the court to get a record of the proceedings so that that person can properly represent the accused. So it's not a complete break in representation. The attorney would be in a position to instruct new counsel. So I don't think that it will necessarily have an impact, but on the other side of things, you might have a situation where a new counsel coming on board would not be comfortable with simply taking instruction. Especially with the technical issues raised during cross-examination, there's only so much that can be explained by an attorney, so it might be necessary to get transcripts and so on and so forth. So it really depends on how the situation unfolds, and both on the side of Advocate Tefu's charges and how the trial unfolds and the conflicts in those proceedings.
Thank you so much. That was Jocelyn Fember speaking to us here, just unpacking that very complicated and complex week of both cross-examination, evidence in chief of the first state witness in the Senzo Meyiwa trial, a much anticipated trial that has taken 8 years to get into a courtroom, and we've tried to ventilate some of the issues we saw come out and get context from the legal aspects so that we understand better the proceedings. As we know, the proceedings will resume on the 30th of May with the cross-examination of Sergeant Thabo Mosia continuing